You are welcome back to the second segment of Contract of Sale of Land, Start Conveyancing Part 1. Types of contracts of sale of land. We said we have oral contract, which is usually an agreement that is reached by parties to a sale of land transaction in which the terms that they agreed upon are not reduced into writing. And you should know that this is generally unenforceable for non-compliance with Section 4 of the Statutes of Fraud, although it is not void or voidable. We may then look at it maybe as a valid contract that suffers from a procedural defect. Even though we said oral contract is unenforceable for non-compliance with Section 4 of Statutes of Fraud, there are, however, certain exceptions to its unenforceability, one of which is sale under customary law. By reason of Section 5, subsection 3 of the Law Reforms Contract Act and Law of Lagos State, the Act, and also the law is still the same, Section 5, sub 3. Sale of land under customary law is expressly excluded from its purview, from the purview of the Law Reforms Contract Law. See the case of Alake and Awawu, Gaji and Peyi, and Etajeta and Ologbo. So, what are the elements of sale? Is not, or customary law, sale under customary law is not in the is not included in the provisions or under the purview of the Law Reforms Contract of Sale Act or law. Sale under customary law, provided there is the payment of the purchase price. Sale under customary law is valid, provided it can be shown, or provided these three elements can be proved by evidence: payment of purchase price, with the purchaser put in possession in the presence of witnesses. In the presence of witnesses. See the case of Egonu and Egonu, and also see Folarin against Durojaye. The Supreme Court has held times without number that there can be no valid sale of land under native law without the payment of money and delivery of possession of the land sold in the presence of witnesses. Now we move on to, does that mean, let's look at this question. I remember the last exam, there was a question that touched on this. One will say the key elements of sale under customary law is the payment of the purchase price with the purchaser put in possession in the presence of witnesses. Does that mean that it's in all cases that a purchaser is put in possession that the sale is valid? What of instances where the purchaser is put in possession and he fails to complete the payment of the purchase price? Does the holder of land or the owner of land who purported to sell, does he have any remedy against such a purchaser? On the authority of Odusoga and Ricketts, such a vendor has a remedy. Therefore, we can say that there is no valid sale where a purchaser, though in possession, fails to pay up the balance of the purchase price. There will be no valid sale or there is no valid sale where such a purchaser, though in possession, fails to pay up the balance of the purchase price. Therefore, a vendor, except he waives his right or agrees to an extension of time for the purchase price to be paid, can validly resell the land or the property, provided the agreed time for payment has passed, or where there was no agreed time for payment, a reasonable time has passed. And don't forget, it is the court that determines what amounts to a reasonable time. This is one of the disadvantages of oral contract. Apart from this being unenforceable, the court will impute terms into payment, and where there is default, the court will be the one to determine what amounts to reasonable time if it becomes a farting issue. Now we move on to acts of part performance. Where a purchaser or vendor is able to prove sufficient of part performance, the court may grant the equitable remedy on specific performance, provided there is a subsisting and binding contract and the circumstances of the case permit such a grant being made. See the case of International Textile Industries Nigeria Limited against Aderemi and also Adesoye and Gardner. But care should be taken here because an order for specific performance is a discretionary remedy. Therefore, a party seeking it should also pray in the alternative for a refund of money paid. Then also sale by the court. Sale by the court. Of course, when a court in exercise of its power makes an order for vesting a property on a purchaser, it is a valid sale in the eye of the law, even though there's no adequate written memorandum evidencing such a sale. Then written evidence rather of an oral agreement is another exception to the unenforceability of oral contract. We now move on to the second type of contract of sale of land, which is the open contract. This is a contract that provides for the barest minimum requirement of Section 4 of the Statutes of Fraud. Provides for the barest minimum requirements, which refer to the parties. It sufficiently describes the parties. 2, it sufficiently describes the price. 3, it sufficiently describes the property. And then it is signed by the party against whom it is sought to be charged or enforced, that is the vendor. See the case of Soyino against African International Bank, and also see the case of Kachala and Banki. The disadvantages of open contract, or the major disadvantage rather of open contract, is that apart from these 4 points on which the parties agree on, which is parties, the price, the property, and the signature of the vendor, every other term is left open. That's why we call it open contract. The law is relied on where there is a dispute to imply all other terms. And this usually work hardship against the parties. For example, in Gaji and Peyi, the Supreme Court implied a sale under customary law into the transaction between the parties, though neither the vendor nor the purchaser pleaded native law or custom as the basis for their transaction, or even gave evidence to support the Supreme Court's conclusion. So you see that an open contract is not the best is not to be encouraged. Now let's look at certain documents that have been held to amount to or to constitute to an open contract by the courts. Letters that sufficiently contains these four issues we have raised. That is the name of the parties, the price, and the property. And then signed by the party against whom it is sought to be charged. Once a letter or by joinder of documents, these facts can be gotten. The court will hold that an open contract existed between the parties. Then, of course, receipt, sale of land receipt. Many of us come from villages or environments where the only document of evidencing the piece of land you bought is a sale of land receipt. Then the rough draft of an agreement have also been held to amount to an open contract. Now this takes us to the formal contract. A formal contract is usually prepared by a solicitor, and in addition to the 3 P's of an open contract which we have discussed, which is the parties, the price, and the property, it goes on to contain other terms expressly agreed on by the parties. And note that parties may decide to create an agreement that is open in part and formal in part. Therefore, a formal contract is enforceable. It contains express terms or conditions agreed on by parties, and it is advantageous to the parties. We will be looking at the advantages later on as we go. Now we go on to conditions. What are some of those express conditions or terms that the parties usually agree on when it comes to a formal contract? One is the capacity of the vendor, that is in which he is conveying. Is he conveying as a beneficial owner, a trustee, a mortgagee, a personal representative, a settlor? Because capacity, you will remember, determines, you've been taught under deeds. Capacity determines the covenants to be implied into the agreement between the parties. So it is important that the purchaser gets a lucid and clear statement from the seller or the vendor as to the capacity in which he is conveying the property. Then we move on to deposit. Where they have finished negotiations and have agreed on price, where the purchaser cannot pay, or it doesn't have the means of paying the entire money, the entire consideration for the sale of the property, parties usually will agree that the purchaser pays a sum, a specific sum or percentage of the consideration as deposit, depending when they are ready to go on to completion, and the purchaser brings the balance. And the deposit is usually 10% of the purchase price, but parties can choose to agree on less or more. And this is usually paid to the vendor, solicitor, or estate agent, either as an agent or a stakeholder. That is why we ask agent or a stakeholder in what capacity. If you are the solicitor to the vendor, in what capacity would you agree to hold such a deposit? In the absence of an express contrary agreement, the solicitor or estate agent usually holds the deposit as an agent of the vendor. See the case of Edgel and Day, and Ryan and Pickington. But note the following: where you decide to hold such deposit as an agent, You are liable to account for any interest that accrues on the deposit while you are holding it as an agent. You are liable to give an account to the vendor of any interest that accrued on that deposit. And of course, holding it as an agent is beneficial or advantageous to the vendor all round, because where he needs immediate cash too, because you are his agent, he can demand for the deposit and receive it even before completion, before the parties are ready to go on to completion. However, if you expressly state, or if it's expressly stated that you are to hold it as a stakeholder, it should be paid to you as the vendor solicitor as a stakeholder, and this is what you should insist on, because as a stakeholder, the vendor solicitor, that is you are acting as a middleman between the vendor and the purchaser. You as the solicitor cannot hand over the deposit to either of the parties without the consent of the other until the completion date or when parties are ready to go on to completion, or where there is a default by either party. And even when there is a default, you are to hand over the money to the party that should receive it under such default. If the default is from the vendor, the deposit should be handed back to the purchaser as agreed. If the default is on the part of the purchaser, then depending on what deposit should be handed to the vendor, depending on the agreement of parties. So you cannot hand over the deposit to either party without the consent of the other until completion or default by either party. And then it is also advantageous to the purchaser. The vendor solicitor holding the money as a stakeholder is advantageous to the purchaser because he is assured, such a purchaser is assured of the safety of the deposit. And then to you as the lawyer, the solicitor holding the money as a stakeholder, it is also advantageous to you because you are not required to give account of interest that accrues on the money while it is in your keeping. But note your ethical responsibility in such a case. You are to keep that money safe. Where it is lost while it is in your custody, you will be held personally liable. Or where you misappropriate such money, note the penalties stated under the rules of professional conduct. Now we move on. You always hear people going to the market. You have even done it. All of us have done it at one point or the other. We go to market to negotiate for maybe a piece of cloth. After all the dickering, you finally agree with the seller for maybe the price of maybe for 2,000 naira. You know, say, I don't even have enough money here, but I love this cloth so much. Okay, madam, let me give you part of the money. Next market, I will bring the balance and then I can pick the cloth. In fact, even if you say you want to go with the cloth, the seller will say, no, I can't release the cloth until you bring the balance. At times you hear there are two words that are always featuring in such a transaction, such an agreement. I'm giving you this 1,000 naira as deposit. Somebody will say, I'm giving you this 1,000 naira as part payment. When I bring the balance, I'll pick the piece of cloth. Now, looking at that general commercial transaction, does it have any effect under a sale of land transaction? Is there any difference is there any legal difference between a deposit and a part payment in a sale of land transaction? The answer is not very, in answering that question, it is not a, what word do I use now? The answer is not so clear, or you cannot unequivocally, rather, let's use that, we cannot unequivocally just say, yes, there is a difference, because there is an interrelationship between the two concepts. Now, what is a deposit under a sale of land transaction? This is usually a percentage of the price which is paid by the purchaser as a show of willingness to be bound and his readiness to complete the transaction at the stipulated time for completion and on the agreed terms. A deposit may also be regarded as a part payment, because at completion, that deposit is usually deducted. The deposit that the purchaser paid is usually deducted from the outstanding purchase price. But the legal effect of a deposit and a part payment, if we say that a deposit may be regarded as part payment, since at completion it will be deducted from the remaining price, what then is a part payment? A part payment, on the other hand, you can see it as it presupposes, when you say okay, he paid part of the purchase price, it presupposes the fact that the agreement between the parties has been concluded and the purchaser has paid part of the agreed sum. So while the other one, a deposit, is a show of willingness to be bound, a part payment, on the other hand, is seen as paying part of the agreed sum in an already concluded transaction. Now, the legal effects of these two concepts, are they the same? The answer is no. For example, where a purchaser is in default, where deposit is paid, he will not be entitled to a refund. But under a part payment, such a purchaser is entitled to a refund, subject to the right of the vendor to bring an action in damages or costs. And then where the contract also fails due to the vendor's default under a deposit arrangement, the purchaser can, in addition to a refund, also sue the vendor for interest on deposit. But note that this should be expressly included in the contract of sale of land agreement. It should expressly be included for the purchaser to be able to enjoy this right. While on the other hand, under a part payment, where either party is in default, under a part payment, please note, where either party is in default, the remedy is either a debt recoverable on the part of the vendor or purchaser, an action for specific performance, or an outright repudiation of the contract. See the cases of Thomas and Brown, Bio and Aku. Then compare with Abidogun and Ologumeta. Now we move on to balance and interest on balance, or simply called the payment of balance and interest. For this, parties in a sale of land transaction, or in the contract of sale of land agreement rather, the vendor specifically should insist on providing for a time frame within which the balance owed by the purchaser will become due. Should agree on a time frame on when the balance becomes due. Usually parties will agree that the balance becomes due at completion, the date they agreed to go on to completion. And they should also agree where that date comes and the purchaser is not ready to go on to completion because his money is still not complete. They should agree on the percentage of interest that is to be paid on that balance. And under common law, the interest was usually 4% of the balance. See the case of Easdale and Stevenson. However, a prudent solicitor should advise his client, the vendor, to provide for the going bank's CBN rates. Then we move on to date of completion. Date of completion. Both at common law, equity and statutorily, time is usually not of the essence when it comes to contracts of sale of land. The law usually presumes completion within a reasonable time, and what amounts to a reasonable time will usually be interpreted by the courts, taking into consideration the circumstances, the parties, and the nature of the transaction. See the case of Otushoga and Ricketts and Johnson and Humphrey. Therefore, to avoid the hardship that may arise from the interpretation of what amounts to a reasonable time, it is advisable to provide for a date of completion in the contract of sale of land agreement, thereby making time of the essence. See the case of Reynolds Construction Company against Edowoyin. And you should note too that the date of completion also determines when interest payable on default by the purchaser begins to run. And this date also helps either parties decide on the course of action to take in case of default by the other party. Now, possession before completion. Ordinarily, a purchaser is not entitled to possession until completion, but parties may agree otherwise in the contract of sale of land agreement. But note, if you are acting as a lawyer to the vendor, advise your client, insist and let it be stated in the contract of sale of land agreement that the purchaser is going in as a licensee. See the case of Street and Montford and AP Limited against Owoduni. Now, payment for fittings and fixtures. Where these are included in the sale, that is in respect of developed properties, and the fittings and certain fixtures are included as part of the sale. And they are quite substantial, their value is substantial. It is advisable that this should be stated distinct from the purchase price of the actual property. And it's also advisable that the legal interest in respect of such fittings and fixtures be transferred using the contract of sale of land, since they are movables. And this is beneficial to the purchaser who pays a lesser stamp duty, because stamp duty payable in respect of the contract of sale of land agreement is at a fixed rate by virtue of Section 28 of the Stamp Duties Act. Now we move on to risks and liabilities. Though Legal title does not pass to the purchaser on the exchange of contract, but the purchaser becomes the owner of the property at equity, and the risks and liabilities in respect of that property moves to him. Therefore, he is the one that stands to lose more where the property is destroyed before completion. Because apart from that, why he stands to lose more, his deposit or his part payment is there. He is seen as the equitable owner of the property. All the risks and liabilities are moved to him, and he is bound to pay the balance of the purchase price even when the property is destroyed. In the case of Castilian against Preston. That is why it is advisable on the part of the solicitor's purchaser, the solicitor to the purchaser rather, to advise his client to go ahead to insure the property, even in cases where the property is already insured by the vendor. He should advise, depending on the nature of the property, should advise his client to also go ahead to insure. And then parties can also disagree that the risks remain with the vendor until completion. Where this is agreed, is also beneficial to the purchaser. Then note section 72 of the PCL and the Insurance Act, section 67 sub 1 of the Insurance Act, that provides statutory protection for a purchaser in cases of destruction of such a property. Now we move on to exceptions and reservations. If there is any exception or reservation that the vendor desires, he should ensure that such is incorporated into the contract of sale of land agreement. Otherwise, he will forfeit the right to the enjoyment of such exceptions or reservations. See the case of T-Bay and Manchester Railway Company. T-Bay and Manchester Railway Company. We go on to look at, before we go on to contract of sale of land and the Land Use Act, we should note that there are instances that a purchaser may not have the entire money or have a known or a designated source for raising the money he tends to use in acquiring the property. That is, he may have to rely on a loan. He may have to apply for a loan to enable him acquire the property. Therefore, it is advisable and prudent for a purchaser who is relying on a loan to finance the purchase of a property to negotiate the inclusion of a subject to mortgage clause in the contract of sale of land agreement. This will enable him or her avoid the risk of being compelled to proceed with the purchase or forfeit the deposit, as well as being sued by the vendor for damages where the loan is not approved. Note that the property that is the subject of the contract of sale of land with the consent of the vendor can be used as a collateral for the proposed loan. Then, on the other hand, a vendor who agrees to include a subject to contract clause in the contract agreement is advised to protect himself by a clause or proviso containing his remedies in the event that the transaction fails as a result of non-approval of the loan or any other act of the purchaser. A subject to contract clause should include the following: the name of the purchaser's intended mortgagee, the amount needed by the purchaser in order to proceed with the sale, the time within which the loan is to be approved, the approved loan is to be gotten, and the remedy of the purchaser where loan is not approved, and where the vendor insists on including a clause for its protection, that clause too should be included in the subject to contract, or it should be a separate clause standing on its own, or it should be attached as a proviso to the subject to contract clause. Now we move on to Contract of Sale of Land and the Land Use Act. A contract of sale of land is generally seen as an agreement to alienate and not an actual alienation. It therefore does not amount to a breach of the requirement of consent under the Land Use Act. Now we move on to exchange of contract. Exchange of contract. This is the procedure by which a contract of sale of land agreement is made binding between parties to it. The exchange may be physical or constructive. You can do present through telephone, through post, through email, even social networks, so long as the parties agree on that mode of exchange and the material time that exchange will be deemed to have taken place. Now, the importance of this procedure of the exchange of contract. Until this exchange takes place, there is no contract between both parties, or even if they have executed the agreement. It is the exchange that makes the contract binding. See the case of Eclipse and Bryant. So please note it. It is the exchange of contract that makes a contract of sale of land agreement binding between parties to it. Even if they have executed it, until exchange takes place, it is not binding on them. Now, the procedure for exchange. The vendor solicitor will usually prepare and send a copy of the contract of sale of land, a draft or a copy of it, to the purchaser solicitor for perusal and amendment for perusal, pointing out if there are areas they don't agree on, it points them out, and this continues until they agree on all terms. On the agreement on all the terms, the purchaser solicitor, the vendor solicitor will produce 2 or more clean copies and send a copy to the purchaser solicitor for execution, while he retains the other copy for the vendor to execute. Once the purchaser signs or executes that agreement, the rule is that he moves the vendor by taking his own signed copy of the contract of sale of land agreement to the vendor's solicitor or to the vendor's place, depending on where they agree that exchange will take place, together with the deposit in exchange for the vendor's signed or executed copy. It is this exchange that makes the contract binding, and the exchange can be at the vendor solicitor's office or at the vendor's house. Now we go on. Can a solicitor act for both parties? Ordinarily, by the rules of professional conduct, it is not advisable for a solicitor to act for both parties in a sale of land transaction. However, there are certain circumstances that may necessitate or make it necessary for a solicitor to act for both parties. For example, where the title to the property is sound, where there is no likelihood of conflict between the parties, where the transaction is of no serious legal consequence, or where the parties consent that a single solicitor should represent their interest in the transaction. Again, where the purchase price is not much, is small, or is not considerable, and where the terms of the contract have been fully negotiated and agreed on by the parties. A single solicitor under these various circumstances can act for both parties. And then how does exchange take place? Where a single solicitor acts for both parties, there is no need for physical exchange. Exchange is deemed to have taken place once the parties sign the documents, the contract of sale of land agreement. Now, advantages of a formal contract. What are the advantages of a formal contract? Look at this. Just mention a few here. One, it ensures certainty of terms. It crystallizes the positions of the party at an early stage, and parties are usually bound by the terms of the contract, thereby preventing last-minute withdrawal. It prevents gazumping on the part of the vendor and gazundering on the side of the purchaser, and also gives the purchaser time within which to investigate the vendor's title. It can also serve as a vehicle for conferring special advantages on either of the parties, for example, possession before completion, exception and reservations, and so on. And then the equitable doctrine of conversion applies. The purchaser becomes the equitable owner of the property on exchange of contract. And then it can also be used to transfer interest relating to chattels. And this is advantageous to the purchaser who pays lesser stamp duty. Now, rights and obligations of parties in the contract of sale of land agreement. The vendor becomes a trustee of a special kind. The vendor is also entitled to rents and profits, except otherwise provided. The vendor has a lien on the property for the unpaid purchase money, and while the purchaser, on the other hand, becomes the equitable owner. The purchaser becomes the equitable owner, and the purchaser's equitable interest in the property is transferable. The purchaser can also protect his equitable interest where required via injunctive remedies, restraining the vendor where he wants to deal with the property contrary to the interests of the purchaser, or is committing any act of voluntary waste. And note that debt does not terminate obligations of parties. The personal representatives of either party can be compelled to complete the transaction. See Section 4 of the CA and Gwangwam against Gagari and Gagari. Now, perfection of a contract of sale of land agreement. Consent is not applicable, and of course, we said stamping is a flat rate.